Broadcast of the 5-part webinar series that is being put on by the ACS Chemistry and the Law Division. I'm Mike David, and I'll be your host for today's broadcast, which is focusing on considerations for license agreements and some other basics of licensing. We will be joined today by Brian Casadon and Krista Bianco from the firm Finnegan, Henderson, Faribault, Garrett, and Dunner. If you have any questions or comments, you can enter those using the questions panel. The slides for today's webinar can be downloaded from that same control panel, and the recording will be sent to you once it has been posted. And now, I'm pleased to turn the time over to Krista.
Thanks, Mike. My name is Krista Bianco, and I am the current program chair for CHAL, and also a past chair. In the first two webinars of the series, we discussed some of the procedural and legal aspects of obtaining a patent, as well as the different types of patentable inventions in drug development. In the third webinar, we discussed important issues that should be considered when you want to enter into a collaborative research agreement. In this fourth webinar, Brian will provide an overview of IP licensing, including basics on the types of licenses and the key clauses found in most licenses. Brian focuses his practice on patent and technology licensing. Over the course of his career, he has drafted hundreds of patent, know-how, and software license agreements in many industries, including pharmaceutical, chemicals, medical device, and consumer electronics. Brian is a frequent presenter at workshops and conferences and has lectured on drafting patent and know-how licenses for the Patent Resources Group, the Licensing Executive Society, as well as other organizations. Brian is also currently an adjunct professor at George Washington University School of Law. With that introduction, I will turn the webinar over to Brian.
Okay. Thank you, Krista. So today we're going to be talking about some basics of intellectual property licensing. And IP licensing is really a very different breed of contract from maybe some of the other agreements that many of you may be familiar with. I think the biggest difference that we have here is in trying to deal with licensing an intangible asset like a patent or a trade secret. There's a lot of considerations that need to be thought of at the time you're actually putting your agreement together in terms of how you are going to describe what it is you're giving to the other party, what kind of payment you're going to receive for that, and also trying to consider what types of problems might arise in the future. We could obviously spend probably several days talking about all the aspects of IP licensing, but today I'm going to try to focus on a couple key general aspects. First, I'm going to talk about just some basic overall principles with respect to the drafting of license agreements. I'll then talk about a couple of the more common types of licenses, and then finally I'm going to try to briefly touch on some of the more important provisions that you might find in a license agreement, identify some common problems that often come up, and hopefully give you some solutions for how to address those problems. So to start with general licensing points, one thing that's always important to keep in mind when you are putting together a license agreement for your intellectual property is that the license needs to be comprehensive in nature. Particularly in the United States, we have a general rule in most states that if something is not in the contract, a court is not going to put it there for the parties. And so the entirety of the agreement really needs to represent the final embodiment of what the parties intended. It needs to address anything that the parties might believe is a potential problem or issue. And if at all possible, courts are not going to go outside of that. They're not going to want to hear the testimony of the parties or look at prior agreements or prior emails. They're really just going to look at the document itself. And so it's really important, if you are having discussions leading up to an agreement, that you don't rely on those prior discussions to inform what the agreement means. You should actually have it in the agreement itself. In the same regard, when putting together a license agreement, clarity is by far the most important thing. In my experience, and I do a fair amount of litigation and arbitration relating to agreement disputes, 9 times out of 10, maybe even 99 times out of 100, the disputes generally arise from some ambiguity or vagueness in the agreement. And so whenever possible, you should always be striving to make the agreement as clear as possible. Consider that a later reader of the agreement, somebody who perhaps has no history with the deal, is going to be the one who has to interpret this agreement at some point in the future. And so avoiding ambiguous language or vague language is a good way to avoid potential problems down the road. That being said, we also have to recognize that the language, particularly the English language, is not perfect, and that there may always be some ambiguity that will have to be tolerated. And sometimes this will have to be tolerated because it's the only way that a deal can get done. I think of examples from my own practice where the parties have reached agreement on the principal terms of a license, including the scope of what's being granted and the consideration, but there may still be some remaining dispute on, for example, the level of detail that needs to be reported as part of a royalty reporting clause. The parties could spend months arguing over that, or they might just decide to say the licensee will provide a report in sufficient detail to allow the licensor to determine the amounts due. Does that tell you exactly what needs to be provided? No. But the parties are leaving that as a negotiated ambiguity for something to be resolved later if it becomes a problem. These are always two competing issues, and while we're trying to be clear, we also have to recognize the practical realities of business and getting the deal done. One other thing that I would also remind you, or something to keep in mind when you're putting together your agreements, is that there's a general principle of contract construction that says if you use different words in an agreement, a court's supposed to presume that you mean two different things. And so if you use words like intellectual property, patents, trademarks, copyrights, technology, all in the same agreement, a court is not going to interpret those terms to mean the same thing. And so it's very important to consider using definitions in your agreement, and I'll talk about a couple definitions in a moment that come up a lot, and make sure you use those same terms consistently over and over again. I often joke with my students at GW that many of us were taught in English class at some point that using the same word over and over again makes your writing boring, and so to be more interesting you should vary your terminology. Well, I always say with respect to contracts, they should be boring. And so you should be using the same word over and over again. If somebody tells me that they have an interesting contract they want me to review, I can automatically assume that there's going to be a problem. So consistency in terminology is extremely important. So that was some of the more high-level points about licensing. I now want to talk about a couple of the most common types of licenses. And in particular, we're going to talk about non-exclusive licenses, exclusive licenses, and a covenants not to sue. Now, I should be clear that there are other forms of licenses out there that we're not going to be touching on in our short time, but I think these are the three that you may see most often, and so I thought it was worth at least covering the basics of what these different types of licenses mean and what these terms mean. And we'll start first with non-exclusive licenses. Now, a non-exclusive license is at its core simply a promise not to sue another party for what would otherwise be an act of infringement. Many people make the assumption that if they get a patent or they're awarded a patent by the patent office, that automatically means that they have the right to practice that patent. But in reality, what a patent gives you is it gives you a right to exclude others from practicing the technology that is claimed within your patent. And so when you grant somebody a non-exclusive license under a patent, what you are saying is that I am not going to sue you if you engage in activity that comes within the scope of my patent. It is not actually a promise that the licensee can actually engage in that activity because there may be other intellectual property that needs to be licensed as well. So it's important to keep that in mind when you think about what you're getting in a non-exclusive license. You're also not getting protection as a non-exclusive licensee from, for example, the patent owner, the licensor, granting licenses to others on better terms, or perhaps allowing people to infringe the intellectual property. And so absent negotiating for something in a contract, and we'll talk about how you can do that in a few moments, you should understand that even though you are taking a license that you may agree to pay 5%, and there's nothing that prevents the patent owner from going out and granting a license to somebody else at a 4% rate or a 3% rate. Of course, with a non-exclusive license, the licensor is free, as I said, to grant other licenses to any other entities. The one protection you do get with a non-exclusive license is that we like to say that a non-exclusive license runs with the patent. And what that means is that it essentially acts like an encumbrance on a patent and stays with the patent even as the patent is sold to a different party. And this is true even if a purchaser of a patent is unaware of a license. This may come as some surprise, but it is often the case that when there is an acquisition or a sale of a patent asset, that the purchaser may not be able on its own to learn the existence of licenses to that patent, because at least in the US there is no requirement that the parties actually record the license agreement anywhere in any government office for it to be effective. And most agreements are confidential. And so it is possible that you could acquire a patent that has several licenses to it without ever knowing it. And so that being the case, just as a sort of separate due diligence point, if you're ever acquiring patents, one thing you want to make sure is to ask the original owner, are there licenses? And if they tell you that there aren't, then to make sure that you get some kind of protection or representation in the agreement that confirms that fact. As a licensee, however, you should keep in mind that you will have this protection in that even if the patent is sold to someone who doesn't know of the license, you will continue to be licensed under that patent. Okay. We're now going to talk about exclusive licenses, and with that I have, before we get into it anyway, I have a trivia question here, and so I'll turn it over to Mike to ask the trivia question.
All right, so our first question today is kind of quizzing what you know about exclusive patents. I'm going to read through these once, and then an interactive window is going to pop up, and you can select the correct answer. So an exclusive patent license means the licensee will be the only entity practicing the invention. No other licenses have been or will be granted. B, when one and only license is granted going forward, the licensee can exploit the intellectual property rights. C, the patent owner may have granted non-exclusive licenses in the past, but going forward, the licensee will be the only entity practicing the invention. Or D, the patent owner may have granted non-exclusive licenses in the past. Going forward, the licensee and those prior non-exclusive licensees will be the only entities practicing the invention. So that was a little bit of a mouthful there, but if you could now select A, B, C, or D right on this blue screen. And as you're doing that, just a reminder that the earlier you ask questions, the more of a chance we'll have to get around to your question in particular. So no need to wait until Brian is done with his presentation. And with that, I'm going to close this poll in 5, 4, 3, 2, 1. Well, Brian, it was pretty set out. A was the most chosen response with 41%, and then D had 23%, and the other two didn't break the teens. So what is the correct answer?
Okay, well, I'm not surprised by the answer there, but the correct answer here is actually D, though I think most people expect the answer here to actually be A. And so that's why I'm not surprised that most people picked A, because I think the common assumption is somebody tells you they are getting an exclusive license, that means that I am going to be the only person who has the right to practice that technology. It makes sense. That's what the term exclusive seems to imply. But one sort of quirk of licensing law, at least particularly in the United States, is that the grant of an exclusive license basically is a promise by the licensor that they are not going to grant any further licenses, that they will not license anybody else in the future. It is not a promise that there have not been pre-existing non-exclusive licenses granted. And so it is possible for a patent owner to grant one or more non-exclusive licenses and then subsequently grant an exclusive license. And that exclusive licensee would again be protected from the patent owner granting any further licenses, but would be practicing alongside those prior non-exclusive licensees. And so this highlights another very important point if you're negotiating an exclusive license, and that is you should inquire of your licensor or the patent owner, are there any prior licenses? And if they assure you that there are not, then make sure again that that is confirmed in the agreement. So I chose that specifically as a trivia question because I think that's something that is assumed but unfortunately is not always correct. And so it is something that needs to be checked on. Now, the other part of an exclusive license that you should recognize is that when you are granted an exclusive license, the patent owner is also promising that they themselves are not going to practice the licensed patent. And so if you are in the position of wanting to grant an exclusive license, but say you would like to continue practicing the technology, perhaps for non-commercial reasons, just to do internal research, as is often the case, let's say with a university, you can do that, but it needs to be done explicitly. The agreement needs to provide for a reservation back to the licensor or the patent owner of the right to continue to do that research. You'll sometimes hear this referred to as a sole license. A sole license is basically a term of art, meaning a license where there's been an exclusive license granted, but the patent owner has reserved some right to practice itself. Okay, so that's exclusive licenses. Moving on, the last type of agreement that I wanted to discuss is what's called a covenant not to sue. Now, often we see covenants not to sue, or sometimes referred to as non-assert agreements, in the context of when there are infringement disputes or possible litigation between parties. And one question that often arises is, well, if I agree not to sue somebody for infringement of my IP, or say I'm not going to assert my IP, is there any difference between that and a non-exclusive license? I'm going to go back a couple slides just to show you something real quick, which is that on the non-exclusive license, I said this is a promise not to sue for what would otherwise be infringement. If we go forward back to covenant not to sue, those start to sound very, very similar. And so the question is there any real difference between the two? And unfortunately, the law is not entirely clear on this point, but one area where there may be a difference is with respect to how a covenant not to sue applies after a patent has been sold. I told you earlier that a license runs with the patent, meaning that once the patent is sold, the purchaser takes it subject to the license. Covenants are often considered personal promises, and so it is arguable that a covenant not to sue would not pass with the purchase of a patent. And so that being the case, if I were receiving a covenant not to sue, I would want to put something in my agreement that required the patent owner to impose that covenant on any subsequent purchaser of the intellectual property. Now, one area where covenants not to sue and licenses are similar is the doctrine of patent exhaustion, which some of you may not be familiar with, but basically stands for the principle that if I, as a patent owner, sell a patented product or license somebody else to sell a patented product, I generally can't control the further downstream use of that product. That rule also applies if you license somebody to sell a product. And the courts have held that that will apply to somebody who sells a product under a covenant not to sue as well. There's some thought that there might be a distinction there, but the courts have made clear that there is not. Okay, so having gone through the different types of licenses, I now want to talk about some sort of key terms that we see in most agreements. And obviously there will be many more than we can touch on in the next 25 minutes, but I'm going to try to focus on some of the most important ones. Starting with the parties to the agreement. Obviously, the licensor and the licensee in general are usually known when you're entering into the agreement. Could be the patent owner as the licensor, or it could be an exclusive licensee or some other entity that has a right to grant licenses. With respect to the licensee, one of the biggest issues that comes up here is not who is the licensee that's getting the rights, but are there any entities related to the licensee that are actually getting rights? Typically, those licensees will want rights to extend to affiliated companies, such as subsidiaries or parent corporations or brother or sister corporations. One thing that often gets missed, though, is that if you want to include this, this really does need to be defined in the agreement. People assume that terms like affiliates or subsidiary have a well-accepted meaning, but they really don't in the context of a contract. And so if you're going to use a term like subsidiary, consider, does it require majority ownership, such as like 51% ownership, or does it require only 50, or can it be something less than that? You should also consider the temporal component of this, and that is that most companies will change structure in some way, shape, or form over time, and that can include the possibility that a company will acquire a new affiliate or may spin off an affiliate. And if that does occur, what is the effect on the license to those entities? Does a newly acquired affiliate get the benefit of the license or not? Does a current affiliate who gets spun off into an independent company, do they get to continue on with the license? These are things that need to be addressed directly in the agreement. Otherwise, there may be a dispute down the road as to whether or not those parties will in fact be covered. The most common way that people address this is by providing that only affiliates who have rights or who are affiliates during the term of the agreement will actually gain rights to the license. Okay, moving on to some definitions that are often problematic in agreements. One of the most common ones that comes up is the term licensed patents. Obviously, when you're entering into an agreement, it is common, you will know the particular IP that's at issue. Maybe it's a particular patent or a group of patents. But usually a party is going to want to include not just that patent, but perhaps other patents that are in the same family as those patents, other applications that are related, perhaps both in the United States, but also potentially worldwide. And so in this case, again, it's important to be clear in your definitions in the agreement that you are not limiting it to just these particular identified patents, but to also specify that you are including things such as continuations or continuations in part or divisionals. These are additional applications that may cover the same invention or may cover the same invention with some new subject matter. It's also important to make clear that the licensed patents definition is going to include any extensions or reissues of those patents. Again, just to make clear that you are getting the full scope of the intellectual property that you are expecting. A couple other definitions that need to be considered in any agreement. What products are actually going to be licensed under the agreement? Should you identify specific products, or should it be anything that comes within the scope of a patent or the intellectual property? Well, obviously the parties are free to define it however they choose, but keep in mind, if you limit your licensed products to only specific identified products, a court is not going to presume that you intended anything beyond that. And so if there are new versions of the product that perhaps have small modifications but are nonetheless different products, those may no longer be covered. And so you need to think very carefully before limiting your agreement to only specifically identified products. Sometimes it may be better to ensure that you're getting the full scope of all products potentially covered by the IP. Now, if you do want to have a definition of licensed products that is somewhat limited, but perhaps not to specific models, You can limit the scope of licensed products by a field of use. Imagining you had a patent on an engine, you could limit it to engines for aircraft or engines for watercraft. But when you do those types of field of use definitions, give some thought to the things that would be included and potentially excluded from that definition. It's often the case that when we have these types of field of use definitions that there ends up being some dispute over things that are perhaps at the edges or the margins of those definitions. Like if I say the products are automobiles, we would agree that that may cover my standard car and my SUV, but does it include a van? What if it's a small moving van, like something you rent from U-Haul? Are those covered as well? Give some thought to those when you're preparing your definitions. And then finally here, also give some thought to what territory you want to be licensed in. Most agreements, or many agreements nowadays, are worldwide, but of course they don't need to be, and they can be limited to specific countries or specific groups of countries. Okay, after definitions, probably the most important part of any license agreement is the license grant itself. I have given you here just one example of what a license grant could look like. Obviously, there are many different forms in which a grant could take, but to highlight the key elements here, you obviously have the licensor granting the licensee the actual affirmative grant, but then we have what is called the character of the license, calling it non-exclusive. It's of course important to identify whether this is a non-exclusive license or an exclusive license, as we talked about before. You need to identify under what it is that you are granting the license. In this case, we're saying it's under the license patent. And then you have to carefully identify what it is you're granting the licensee the right to do. And in this case, you see that it's the right to make, use, sell, offer for sale, and import licensed products in a particular territory. Now, the rights that you see there, the rights to make, use, sell, offer for sale, and import, those are what we call sort of the standard statutory rights. Those are the same actions that can cause infringement of a patent. And generally, this is the type of grant you will see, but there is no requirement that you grant a licensee all of these rights. You can grant a licensee the right to make and use a product itself without the right to sell. And so you could also grant somebody the right to make, use, and sell and offer for sale, but not have the right to import if you don't want them, for example, making the products overseas and importing them into a particular territory. So don't assume that it has to be all of these rights. You can divide them up. Other things to consider, do you want your licensee to have the ability to sublicense its rights? If so, that's something that needs to be explicitly set forth in the agreement. Otherwise, the licensee will not have that right. Another thing to recognize is that if you give a licensee the right to manufacture a product, that generally implies a right to allow that licensee to have those products made for it. In other words, they will have the ability to subcontract out the manufacture of those products. Now, that subcontract won't give the subcontractor the ability to make products for sale to other third parties. They can only sell it to the licensee. But keep in mind that if you want the licensee to be the only entity actually making the products, then you'll need to specifically carve out any right to have products made for it. Okay. The next part of the agreement that we're going to talk about has to do with consideration and not just amounts being paid, but how do we go about reporting what should be paid and accounting for what has been paid. And the first thing we're going to talk about is payment and royalty reports. Generally, when there is a running royalty in an agreement, in addition to identifying when that payment is due, there's going to be some requirement that the licensee actually report those royalty amounts and how they were calculated. And so in your agreement, you want to give some thought to identifying not just the timing for that report and payment, but also what content is going to be in there. I talked a moment ago about how that may end up being a negotiated ambiguity, but if possible, it would be useful to actually identify explicitly what type of content the parties are going to include in the reports to avoid questions and problems down the road. You should also give some thought to what will happen if there are late reports or late payments. Oftentimes there will be interest due on late payments, but if you don't specify in your agreement that there is interest due, then there is no automatic right to interest on late payments. And so it is a good idea to include in your agreement, at least if you're a licensor, that there is going to be interest due, and to specify what that interest is. And while you can't make that interest rate overly high, it should be a little bit more burdensome than, say, your standard low prime rate, because you don't want your licensee essentially using you as an ability to hold off paying money because the rates they'll owe you on interest are less maybe than they'll owe their bank. One final thing to consider here is whether there's going to need to be any income tax withholding with respect to any payments. This is an issue in the context of any international agreement where you have parties located in two different countries. Many countries have a requirement that when a royalty payment is leaving the country, there is a certain amount that needs to be withheld as a tax on that royalty payment. In some countries, that amount can be as high as 15 or 20% of the amounts paid. And so if you as a licensor are expecting a payment of $1 million and only receive $800,000, you obviously might not be too pleased with that fact. Now, this doesn't mean that you're necessarily out that extra $200,000. What it means is that the parties need to address this ahead of time. Many countries, particularly many of the developed countries, have international tax treaties with one another. And the way that this is dealt with is that the licensee who had to pay the tax, they will give a certificate to the licensor showing that that tax was paid, and the licensor can actually use that certificate to take a credit against the taxes in its own home country. But if the parties are located in countries where there is not a tax treaty, or if the licensor is, for example, a nonprofit like a university who can't take the benefit of a income tax credit, then the parties will need to address ahead of time who's going to be responsible for that withholding tax. Okay, now in addition to dealing with royalty reports and payment, you also need to consider the possibility that the licensor may want some right to audit the licensee to determine whether or not the correct amounts were actually paid. This doesn't imply that the licensor doesn't trust the licensee, but it's just a reality of business that oftentimes things get missed, often unintentionally, and so it's not bad practice to consider auditing your licensees on occasion. Of course, if you're going to have that right, you need to spell that out and how that's going to work in the agreement itself. Some things to consider, issues that we see often. One, you want to make sure there's some provision for confidentiality, as you're going to have somebody coming in and auditing your financial records. It's also important to make clear that whoever does the audit needs to be an independent, usually certified public accountant. You don't want the licensor sending one of its accountants in to audit your books. You want to make sure it's an independent third party. You should also make clear who is going to pay for that inspection. Typically, the auditing party, the licensor, would pay for it, but you may provide for payment shifting in the event that for example, there is a underreporting discovered over a certain threshold level, the most common threshold level being somewhere between 5 and 10%. The reason behind that is to address the possibility that perhaps if there is such a high level of underreporting, this either implies some intentional withholding of payment, or at a minimum, perhaps some gross negligence on the part of the licensee. Okay, at this point now, we're going to move on to other parts of the agreement, and we have another audience trivia question, and so I'll turn it back over to Mike to ask the trivia question.
All right, so our second and final question is, does a patent owner have a duty to enforce its patents against an infringer that is causing competitive harm to its non-exclusive licensees? And it's a pretty simple yes, no, or it depends, but only when a third party is involved. And everyone is voting pretty quickly, so I'm going to close this poll in 5, 4, 3, 2, 1. All right, Brian, so 43% of the audience said no. The next highest was 35% with it depends, and yes got just 22%.
Okay. Well, on this one, our audience mostly had it right. The answer is generally no here. In the context of a non-exclusive licensee, the licensor generally has no obligation to protect their non-exclusive licensee from competitive harm caused by infringement. And so this can be a real problem as a non-exclusive licensee. If you negotiated a license and agreed to pay let's say a 5% royalty for the rights to use intellectual property, and all your competitors are out there using the same exact technology but paying nothing, obviously you're at a competitive disadvantage. And the licensor generally has no duty to protect you from that type of harm. And so if you want protection, then what you need to do is negotiate for it. And one way you can negotiate for it is by actually including a clause in your agreement that addresses this, and we would call this a third-party infringement clause. Basically what a third-party infringement clause would provide for is it would provide that under certain circumstances the licensee could request and require the licensor to actually take action to halt infringement that's occurring. Obviously, many licensors might be reluctant to agree to sue whenever the licensee wants it to, and so the parties will have to negotiate the circumstances under which it can be forced to bring suit. Things that will often need to be considered here is, first, of course, there will need to be some procedure for the licensee to notify the licensor that it believes that infringement is occurring. And usually that would be in some form of written notice. But beyond that, there may also need to be some requirement of proof that infringement's occurring. Otherwise, is the licensor just beholden to the licensee's belief that infringement's occurring? What if they disagree or they don't believe that the infringement is rising to a level that really warrants having to go through the expense of bringing a lawsuit? So it may not be a bad idea to consider defining in the agreement whether there needs to be a certain threshold level of infringement occurring, perhaps from a monetary or quantitative level, and then also provides for what happens if there is a dispute over whether there actually is infringement at all. One way of dealing with that type of dispute is that you could actually provide for resolution of it by a third-party independent patent attorney. The parties could agree to split the costs and send the issue to a patent attorney who would make a judgment, and if they determine that infringement's occurring, then the licensor would be able to bring action. Other things that you would consider including in that clause, you would consider providing for the licensee to assist in the litigation to the extent necessary. The parties can also consider sharing the costs of that litigation, and typically if there is going to be cost sharing, then there would also be sharing of any damages or money received during or from that action. And then finally here, you also want to give some thought to what should happen if the licensor does not act. Let's say the licensee complies with the provision, notifies the licensor, but the licensor does nothing. Now, generally you would say, well, isn't then the licensor in breach? Couldn't you terminate the license? And that would be true, but that may not be the remedy that a licensee actually wants, because now they are unlicensed and could potentially be sued for infringement. And so oftentimes you want to negotiate for a different remedy. And one remedy might be that the licensee would be excused from paying royalties until the licensor acts again. This would remove the potential competitive harm and also give the licensor some incentive to actually act. Okay. Now, we talked about the provisions we just talked about were with respect to a non-exclusive licensee and what it can do to require its licensor to enforce the patent. does this change at all if we're dealing with an exclusive licensee? Well, again here, the licensor doesn't have an obligation to protect the exclusive licensee, but here the licensee actually has a different option, and that is that under the law, at least in the United States, an exclusive licensee can be granted the ability to sue for infringement. This is not the case for a non-exclusive licensee. A non-exclusive licensee cannot be granted the right to sue for infringement. Even if the parties put it in their contract, it will not be effective. But a licensor can give an exclusive licensee the ability to sue for infringement. The key question that often comes up here, though, is does that exclusive licensee have the ability to sue by itself, or does it have to sue together with the patent owner? And the answer to that question really comes down to whether the exclusive license rises to the same level as an assignment or a sale. In other words, even though title hasn't been transferred, has the exclusive licensee basically been given all the rights under the patent? If they have, then they will be able to sue on their own. If they have not, then they can still sue, but they will likely need to join the patent owner in that case. And since the parties may not be sure as to which will be the case at any point in time, because this could depend on the determination of a court, it's a good idea to provide for both possibilities in your agreement. Now, how would you go about determining whether a exclusive license really rises to the level of an assignment? There's a number of factors here that I've listed. Of course, one, the license really does need to be exclusive. It would also be important that the licensee be given the sole right to enforce the patent. If the licensor has a first right to sue or the potential to stop the licensee from suing, then likely the parties are going to need to sue together. Other factors like the licensee's right to sublicense or assign its license, or whether the license is for the full term of the patent or simply for a field of use can also impact that conclusion. I think what you should assume is that to the extent that the licensor is holding anything back from the licensee, it becomes more and more likely that the licensee will not be able to sue on its own and will have to sue together with the patent owner. This is often important because oftentimes a patent owner may want the licensee to sue without having to be involved, but they're unwilling to give up the control that's necessary to allow for that to happen. And so you have to balance those two things and decide really what is more important, the ability to avoid being brought into the case or the ability to control your licensee. Okay, a couple other provisions just to talk about in licenses. Indemnification. One question that comes up is if a licensor licenses some technology to the licensee and the licensee in practicing that technology ends up hurting someone, or somebody uses a licensed product and gets hurt, and so sues, let's say, the licensee for products liability, does the licensor have any obligation to indemnify them? And the answer to that is generally no. And so if you want indemnification from that, that's something that needs to be provided for. The same is true with respect to infringement claims. If that licensee is accused of infringing a third party's patents, there is no duty to indemnify for that claim of infringement. And so if you want that to be provided for, that needs to be included in the agreement. You want to provide for indemnification, that the licensor will defend the suit. Of course, there also needs to be provision for notice of the suit and who is going to control it. And oftentimes the licensor may want to consider whether it's appropriate to put some limits on liability, such as a cap on the amount that they could have to pay. A couple final points here. Other things to consider in your agreement. The contractual jurisdiction. What we mean there is, where will disputes be heard under the agreement? Do you want it to go to arbitration or a particular forum? It's a good idea for the parties to agree to that. It's also a good idea to agree ahead of time what law will apply to the contract. New York and Delaware being perhaps the two most common that most parties choose. You should also give some thought to the term of the agreement, of course. How long is it going to last? Will it last till expiration of the patents? And also what happens, or when can the agreement terminate? Does it terminate on breach? What happens if there's a bankruptcy? And then also consider, do you need things to survive termination of the agreement? Oftentimes, if there are confidentiality obligations, particularly in a trade secret or know-how license, you would want those to survive. And so that would need to be specifically called out in the agreement. And then finally here, the concept of patent marking is something somewhat unique to the U.S., but it may be something that you want to impose on your licensee. And again, that would need to be specifically spelled out in the agreement. And then finally, just a couple clauses to consider for protection for a licensor, things that could protect the licensor. One would be a minimum annual royalty provision in an exclusive license. This just ensures that you're getting a minimum return on your investment. And of course, if it's not met, then there could be conversion to a non-exclusive license in that setting. And then you could also consider including a best efforts clause, but keep in mind that best efforts is in and of itself an ambiguous term. And so it's a much better idea, rather than using the term best efforts, to establish specific milestones that will satisfy that best efforts obligation, rather than just relying on terms like best efforts or reasonable efforts. One other thing to consider is that if you are getting an exclusive license and even don't include a best efforts clause, one might be implied. And so you may want to consider specifically disclaiming any obligation to exploit the technology. Okay, and so with that, I'll conclude my presentation and I'll turn it over to Mike again.
All right, thank you so much. I just have one brief middle announcement, and then we'll get to your questions. The Chemistry and the Law Division focuses on educating others about the issues that arise at the intersection of chemistry and the law. Make sure to join us for our final broadcast on June 13th, which will focus on joint inventorships of patents. Also, remember that the recording of this and all other recordings are available on the ACS Chemistry and the Law Division's YouTube channel. And with that, Krista, I'll turn it over to you for the first question.
Yes, one of the first questions was asking, Brian, you spoke a lot about the exclusive versus non-exclusive license. Is it important to define exclusive and non-exclusive, or are those established legal definitions?
Those are generally established legal definitions. In the context of an exclusive license, though, it certainly wouldn't hurt to include a clause that specifically identified that the licensor can't grant any further licenses and agrees not to practice themselves. That should be implied, but at the same time, I think spelling those things out is never really a bad idea. And so I would usually include those in an agreement anyway.
One other question was if there's a license agreement between a U.S. entity and a non-U.S. entity where the agreement needs to be translated into a foreign language or into English, what steps could one take to ensure that the translation is legally correct, or which agreement would govern in the event of the dispute?
Okay, this is a good question. I guess one thing that I didn't mention, but you should consider putting in your agreement, is that there is a governing language, and the parties should specify which language will control the agreement. Now, if there is a requirement that by law, let's say a particular country or government requires that an agreement be in multiple languages or be in a particular country's language. For example, in parts of Canada, certain agreements need to be in both French and in English. In that case, it may not be possible to say this one is the governing contract. But whenever possible, even if there is a translation done, I would specify that only one is going to be the official contract. Now, in that instance where there are there's a need for the agreement to be in multiple languages, what I would usually recommend in terms of ensuring that the translations are done accurately, because I have seen many instances where the translations are not done accurately. The best way to ensure this is if you start with, for example, an English version, and let's say we need to translate it into French. I would have a translator, hopefully who I trust, who has some legal expertise, hopefully, or at least some legal experience, and if necessary, you may even need somebody with some technical experience, translate the agreement from English into French. I would then take that French agreement and I would try to find a different translator and actually ask them to translate the French agreement back into English and then do a comparison between the two English versions. This will help you highlight where there are potential ambiguities, because as we all know, there are certain ways in which words are used in context that don't always translate between languages. And so that may help you identify particular problem spots or areas where where the agreement perhaps needs to be made clearer in order to make sure that both agreements govern the same or are interpreted in the same manner.
One other question is there one standard royalty rate in the chemistry industry?
Yeah.
If not, what factors would one consider?
Yeah, that's a question that I get asked a lot is what's the right royalty rate for X or Y, and in the chemicals industry for my particular technology, what's the right rate? And unfortunately, there is no one standard rate. Every piece of intellectual property is somewhat different. We can often find surveys out there that will show ranges of rates in particular industries. If people are interested, the Licensing Executive Society, which is an organization made up of licensing professionals, often publishes surveys. There are other organizations as well. But even there, they're likely only to go down to a pretty high level of granularity in terms of rates. And for any particular technology, the rates could vary greatly. Often the things that you need to take into account or consider, of course, is if there are other agreements out there for technology that is similar, that may be a good benchmark for you to use as a potential royalty rate for your technology. Another thing that you can look at oftentimes is, if the technology at issue, for example, results in a certain cost savings, you may be able to look at the amount that's saved by using the technology and allocate some portion of that to the intellectual property. You can also try to measure the expected economic value of the technology going forward on an income basis and use that as some way to potentially measure the value of the technology, and then again allocate some portion of that to the royalty. At the end of the day, however, there is no foolproof method. I think the only truly accurate answer I've heard to the question of what is this worth is it's worth whatever the other side will pay for it. And frankly, what we're usually trying to do with these different methodologies that I'm talking about, looking at surveys, looking at different valuation analyses, is we're trying to get ranges that we think are appropriate. And hopefully both parties will come in with their ranges and those ranges overlap in some way. And usually the parties will find some point of agreement between their two ranges. And that's often the best that we can really hope for in any particular license negotiation setting.
There's a question too, a lot of these licenses might go across multiple states. So what are effective ways for a licensing attorney to handle deals involving at least one state where they're not licensed to practice law?
Yeah, I mean, this can be a tricky issue, and I'm not going to get into the ethical quandaries of where and when you can practice law. But if you are, a lawyer practicing, let's say in Washington D.C. like myself, it may be the case that you're helping negotiate an agreement between a company in California and a company in Illinois, and that the parties will want California law to govern, and so. What I often recommend as a practical matter in terms of the way in which you draft your agreements is, you can of course always ask for input or advice from other attorneys. There are also resources that you can look at to help you identify potential issues with the laws of particular states. One other thing, I guess, that I would sort of note is that I think this is one reason why a lot of attorneys tend to default to particular jurisdictions, like I mentioned New York and Delaware earlier. They are the most popular, not necessarily because their law is so great. They are the most popular in many ways because those are the states in which there, frankly, is the most precedent regarding contract disputes. And so there's more certainty regarding how things may come out. And so people have more experience with those jurisdictions and have a little more comfort with them. And so You can try to rely more on states in which perhaps the law is a little bit more well settled as a potential for where or the law that you want to choose for the agreement. Where this gets really complicated, frankly, is in an international agreement when you have, let's say a party who wants to choose New York law and another party who wants to choose, let's say, Chinese law or Japanese law, because there the laws may vary greatly. And so in that situation, I always tell people, if you're going to choose an international law, you really do need to get a lawyer from that country to look over the agreement. You can muddle through in the U.S. assuming that most of the state's laws are not going to differ greatly. I would not recommend trying that approach with international law.
And one final question is there a good source of example licensing agreements, or if you wanted some samples, is there any other resources that might be a good place to look?
I almost feel like this was like a planted question, but I swear that it wasn't. I'll mention one resource that's going to sound like a plug, and then I'll mention some others. I'm actually a co-author on a textbook out there called Drafting Patent License Agreements, and as part of that, book, we actually include not just a number of sample clauses. There's also sample forms, and they're basically is provided all through a link to a website. The book's available through BNA if you're interested. That's, of course, not a free resource. I mean, one place that you can also look, there are a number of places on the internet where they collect sort of agreements or sample clauses that you can look through. Another thing that you can do as well, or to consider, is if you know a particular company or industry, sometimes large companies are required to actually disclose some of their license agreements as part of their SEC filings. And so occasionally you can get examples in that manner as well. That may be another resource. But I always caution anybody, whether they're looking at my book or anything else, keep in mind that forms are good to start with, but they're not good endpoints. You always need to modify them.